have sworn an oath to uphold our Constitution and our rights to petition the government. These are the people that have sworn the oath to us. I don't know if you guys know this. It's one of the things the Supreme Court does is they have this little ticker of how many cases they get done and how fast they get them done. I think they get at some party at the end. I don't know. But they have to follow this. This is one of the judges' rules, the court rules from the Supreme Court. You get so many in and you get so many out. And you can't have them hanging along this line. This is part of their rules. So they want to keep things moving, and they're going to try to get you to say, I waive my rights. You don't want a jury trial. They're going to do everything they can so they can keep their calendar going. Okay, and the judges are attorneys that have been trained to follow the rules. They're all this group. They're a fraternity. They're all part of the same yada yadas. And most of them have no concept of law, but they know what the rules are. And they don't understand the difference between a natural person and an artificial entity. So many times I am not an artificial entity. And just like the judges looked at me like, what do you mean? I said, you are. I'm not. What do you mean? You're part of the government. That's an artificial entity. We created the government. I'm a natural person. I have rights. So, judges and attorneys use the rules to prevent your claim being lawfully heard by a jury. Rule 56. Rule 56, that summary judgment. Whatever they can do. Pre-trial motions, this and that. They do all these different rules trying to keep you away from your jury. And the goal of every judge is not to have the parties go to trial. I have this, now, this isn't something I'm just saying. I have the judges' little conference books. They go up to Brainerd every year, and they have this little conference that there's a union. Just like there's a plumbers union, there's a judges union. The judges have unionized, and they go up to Brainerd, and they have their little conference.
Do they wear their robes?
I don't know if they wear their robes. I'm crashing it this year. Anybody want to go on the bus with me? I'm going in. I want to know, because the legislature pays for this. It's over $1 million for this little party they have up in Brainerd. And I've gotten some of the little documents out of there too. The goal of every judge is not to go to trial. They're going to try everything they can not to go to trial. And Rule 56 is one of the biggies. It's where the judge gets, come on guys, give me a rule. Somebody give me a motion for summary judgment. I can get this thing off the calendar. Okay? And the attorneys all know this. So they push for this Rule 56 summary judgment, have the judge decide this thing, even though you've demanded a jury trial, get the judge to decide it, and then you have to go to the appellate court, and easily $20,000 out of your pocket to go to the appellate court. Everybody knows that? All right. So, another one of these little documents that came out of Brainerd was the techniques that are being taught to the judges to stop people in court that do not have attorneys. They have specific set techniques that they use for the natural person who has not hired the attorney. Okay, judges are trained to control you. You are required to call the judge your honor. Now, we are honored here to have Representative Severson, but he's never required me to call him your honor, Severson.
Not yet.
Why? Why do we have to call the judges your honor? They work for me. They work for you. You know, I call him Paul. So, Joanne. All right, judge requires certain etiquette. You must stand when the judge stands and not sit until he says you can sit. Are we in church? You know, all right, I'll sit. Who is this person? This is a judge that works for us, What the judge is supposed to do is keep order in the courtroom. The judge isn't supposed to come in with, wearing a bathrobe, and, they used to have, come on, what would they do to me if I walked in wearing a judge's robe?
One of the goals of the committee here this morning is that we would put these recommendations forward, identify the problems that we're having, and then put forth a recommendation that we can put to the other legislators who are not able to be here, and then generate some legislation that addresses those specifically. And then it would be the job of the citizens here and those who are not able to be here to contact your representative and ask them to support that legislation as it goes forward. I also want to just say, this is a great group of people here. I appreciate you taking the time this morning. Obviously, there's points of interest here. The goal is that people would have a voice in this process. We'll see how that goes. We're going to go from 9 o'clock until 11 o'clock. And
the name is Greg Wersal. Wersal's W-E-R-S-A-L. I'm an attorney. I've practiced law for 29 years in the state of Minnesota. I was a former candidate for the Minnesota Supreme Court. I was the lead plaintiff in the case of Republican Party of Minnesota versus White, which dealt with judicial elections that went to the U.S. Supreme Court. I am currently a candidate for the Minnesota Supreme Court for the elections to be held in 2010, and I am currently suing the state of Minnesota for additional judicial election rules that were created by the Minnesota Supreme Court after we won in front of the U.S. Supreme Court. They just create more rules, and we just have to churn out more litigation. I was asked today to talk about the judicial system, and I would start by saying the judicial system is out of control. And because we have no accountability, and we haven't had accountability for years, we've got a growing problem. The problems are judicial incompetence, judicial abuse, and maybe judicial corruption. I want to talk briefly about judicial incompetence. Almost all the judges in Minnesota, it's well over 90%, are appointed by the governor. And frankly, the governor appoints his friends. And frankly, many of those friends are not intellectual giants. And so we have a lot of mediocre judges. What that means is that we have an instance, for instance, we have the Minnesota Supreme Court, where not one judge on the Minnesota Supreme Court has been a prior trial court judge, district court judge, prior to their appointment. They have no experience on the trial courts. Yet all the cases they're getting before them, they're reviewing trial court decisions. So it just doesn't make any sense, the system we've got. 90% of the caseload in front of district court judges are criminal law and family law cases, and yet many of the governor's friends are corporate lawyers who've never handled a criminal or divorce case in their lives. And that incompetence is then reflected in their decisions. Judicial abuse is the second problem. It takes many forms. And I'll again just give you a couple examples because I know there are going to be many speakers who are going to talk directly about judicial abuse in their cases. But I want to explain a couple of the cases I've seen. The state, several years ago, the legislature created sentencing guidelines. I've practiced criminal law for 29 years, and I'm going to tell you that the sentencing guidelines are commonly ignored in our courts. Another problem is bail guidelines. Just a few years ago, several years ago, the legislature created a rule that said that repeat DWI offenders had to either be given $10,000 bail or be put on an alcohol censor. Yet you can go into courthouses throughout the state and find that that rule is ignored. So what happens is that...
excuse me, did you say the legislature created a rule? Or are you saying it was a law?
The legislature created a law.
Okay,
excuse me,
thank you.
A law. And then let me give you an example of what happens. The best example is out in Willmar. The prosecutors in Willmar looked at the court rules and they said, well, look, we've got a right under the court rules to strike a judge from hearing a case. It's in the rules. Supposedly everybody should be able to do it. So they had a certain judge there who wouldn't follow the guidelines for either bail or an alcohol censor on repeat DWI offenders. So they would routinely strike that judge. You know what happened? There was immediately an action, and the Minnesota Supreme Court was threatening the county attorney's office that with sanctions, that if they continued to persist in filing to strike that judge, that they were going to go after the attorney's license. Now, what we have is the judiciary telling the executive branch, because the county attorney is part of the executive branch, how they should handle their office. And this is a threat to the people of Minnesota, because if we don't have effective county attorneys, we're going to have problems.
I'm sorry, Mr. Worsel. Let me just get clarification that. So the county attorneys said that the judge was not issuing accordance to guidelines and they were striking him from the list, and then the Supreme Court came back and basically said you can't do that or we'll come against his license?
They'll come against the attorney's license, the prosecutor's license. That's correct. Okay. And again, the court rules say you can strike a judge without giving a reason. The prosecutor does not have to give any reason to strike a judge, just as the defense have a right in a criminal case to strike a judge without stating a reason. But again, because it was obvious that there was a pattern, they went after the county attorney. And again, I think this is an abuse of judicial power. Judges have the power to arrest people and throw them in jail. And I still remember to this day in Hennepin County watching a judge who ordered the bailiff to go outside and arrest construction workers who were doing work on the court building. He felt that they were being too noisy. He had earlier sent the bailiff out there to tell them to knock off the noise. Well, they're using jackhammers for they're trying to do a construction job. That's why they're there. The judge had the bailiff go out and arrest them, bring them in, and he threatened to hold them in contempt if they continued to make noise. Now, we don't hear about these problems because as an attorney, who's going to file this complaint? The attorneys are scared to file these complaints. My point to you is judges have enormous power. I have seen judges who are prejudiced, female judges, one, who hates men. It's quite obvious if you've ever been in front of her. I have seen judges who are sexist, men who demean women who appear in front of them, especially women lawyers. I have seen judges whose every other word was a four-letter word that I can't repeat here. I have heard of judges who have changed court transcripts to hide their abuse. Now, that's the kind of abuse we're talking about, and again, others are going to give other instances of that. But we've got the final category, which is judicial corruption. And I want you to understand, I kind of doubt that anyone is going to say that today, specifically, they can point to an instance of judicial corruption. But I want to give an example that happened to me several years ago. I had discovered that Justice Page on the Minnesota Supreme Court had a charity that he ran, and in addition to being a judge on our state Supreme Court. The charity provides scholarship to students. I'm not going to say that the charity isn't useful, isn't beneficial to the people of Minnesota. But what I will say is, before he became a judge, that charity existed, and almost no money flowed into that charity. And after he became a judge on our state Supreme Court, thousands and thousands and thousands and thousands of dollars was flowing into that charity. And if you looked at who the contributors were, because they have to file documents with the state, you find out that many of those contributors were attorneys and law firms that were then appearing in front of our state Supreme Court. Justice Page was not recusing himself in those cases. I filed a complaint with the Board on Judicial Standards, but to the best of my knowledge, nothing happened. The charity still exists and the money is still flowing. There was one change made. Justice Page was actually filing on behalf of the charity documents with the board that governs charities in the state, and he was signing at the bottom who was giving how much money. So it was obvious he knew who was getting thousands and thousands and thousands of dollars. After my complaint, he was no longer signing those documents, but the thousands of dollars were still coming in, and for all I know, he's still able to make requests for that money, etc. This is something that needs to be investigated. There's also a problem that has been talked about somewhat. I think Dale Nathan, who's going to address the committee later, is that the Code on Judicial Conduct allows gifts of up to $150 to be given to a judge, and that the Code of Judicial Conduct doesn't see this as a problem. But what you're going to see is that a lot of the people giving those gifts are lawyers who are appearing in front of the judges. And to the best of my knowledge, no gift can be given to a member of the legislature.
My name is Jill Clark. I'm an attorney licensed to practice in Minnesota, at least as of today I am. We'll wait and see if I still am after this hearing. I am an attorney with approximately 20 years of experience. I have litigated in many venues. I do civil cases in federal court. In about the year 2000, I began doing a lot of pro bono work, vigorously defending people of color in state criminal court. Frankly, I could not believe the way I was treated by numerous judges when I began to vigorously defend African Americans. That list is so long, I'm going to leapfrog over it, but I want to let these members who took the time to come here today and listen to, obviously, many people with concerns, let you know that I am available later. You can call me. I can come over. We can chat. I have numerous documents. I have a lot of knowledge. I want to start by saying that there are many good ethical judges. In no way do my comments today impugn the entire bench. There are judges who care. There are judges who are moral and upright. And there are judges who will do the right thing with pressure from other judges to do the wrong thing. Those people know who they are. They don't need my laud and praise, but I want to acknowledge them. There are numerous problems in the judiciary. I, so to speak, retired in the year 2000, and my motto was kind of, you know, the way that comedian used to say, take my wife, please. If I got under pressure, felt under pressure, I'd say, take my license, please. Put me out of my misery. Keep me from practicing law anymore. But the notion in my head was I had created a platform of freedom for myself, because if I didn't fear them taking my license, I didn't fear them. And I began to be a lawyer who would speak out with due diligence about the facts and due diligence about the law, but nonetheless speak out on behalf of my clients who were encountering problems with the way that the judge was handling the case. These things took many different shapes and sizes, these problems. Ex parte communications, flagrant bias in favor of one party or against another, documents removed from an official court file with all evidence tending towards the judge being the one who made that decision. The documents would have helped my client, but more importantly, they would have gotten the judge in a lot of trouble. I have had cases where, with all due respect to everyone involved in the system, we proved that a district court transcript, a state court transcript, was inaccurate. And it wasn't just any old inaccuracy. When I began vigorously defending people of color in state criminal court, I came flat up against a system that allows police to criminally charge their victims of assault, victims of police misconduct in state criminal court. And it is my belief, with the protection of the First Amendment, that there are judges that help them do it. Not all of these judges, but judges that let police misuse the state criminal justice system to protect police from civil or criminal liability. This is extremely severe. Right now I represent a woman who went to the hospital to report that she was raped by two on-duty uniformed Minneapolis police officers. The Minneapolis Police Department, in its infinite wisdom, issued a press release saying that she'd made a false statement, and guess who's being criminally charged? The woman who was raped. And I've seen the evidence in the case, and the evidence suggests highly not only was she raped, but that there's some kind of cover-up involved. Those kinds of things could not continue but for the help of certain state court judges. Some of it is probably fear. Some of it is probably fear that this groupthink, this culture, cannot be changed. What if I step out? There are probably judges who live in fear of stepping out and speaking the truth, but nonetheless, these things go on. So getting back to this transcript, there was a transcript in which my young African-American client was saying something like, and I'm not quoting it exactly, but something like, everything in the police report is true. I don't have a lot of young African-American 24-year-old clients who would say any such thing in court, either using that language or agree that the police report is true. In this case, this individual had a record of making complaints of police misconduct and speaking out against the police. We asked for an audio tape of that hearing to check the accuracy of the transcript, and we were shut down. We asked repeatedly, and we were shut down. We were told different stories. When we asked the court administrator, we were told, well, it belongs to the court reporter. Well, what public record belongs to a private individual? Then we found an order signed by the chief judge without any process, essentially legislating that all audio in Hennepin County is the property of the chief judge. Again, that's not even a constitutional officer. One judge who's elected to a single seat in Hennepin County cannot hold and own and control public property. We did not get audience, we did not get assistance at the district court, so we had no choice but to file an action in federal court. This is not the preferred course of action. The federal courts really don't have time to clean up the problems with the state judiciary, but we determined that it was our only avenue at the time. We ended up having to sue 2 court reporters and the district court administrator and the chief judge, but with the assistance of the Attorney General's office, we did finally hear that audio tape. And in fact, our hunch was correct. That young black man never said the police reports are true. But if that transcript had stood as it was, and he tried to sue the police in federal court, it would have protected them from civil liability. I am not here today saying that that court reporter is responsible. I think court reporters get leaned on just like judges lean on judges and lean on lawyers. But someone has to stop the madness. Someone has to be able to stand up and speak out. This body should be particularly concerned when judges are essentially breaking the tripartite, stepping out of their role as judicial officers and legislating. And you might want to look into whether or not Hennepin County judges are meeting in secret and passing laws that govern in Hennepin County. And the last time I checked, Hennepin County had not seceded from the Union. I have a lot of documentation on that point. Now, one of the things that I have done is to work within the system, to send the smoke signals up to the appellate courts, to put things in affidavit, to trap documents, get them in the record so that they can go to the Court of Appeals, so that they can do the right thing, and so that they can go to the Supreme Court of Minnesota so they can do the right thing. It is my studied opinion that that was one of the reasons that certain Hennepin County judges, wanted to shut me down. I did make a complaint to the Judicial Standards Board about the Chief Judge of Hennepin County. In my opinion, they did pretty much nothing. They're very secretive about what they do, which is, I think, a problem. It seems the complainant should be told at least what's happening to the complaint, even if it's just public relations, but don't just shut the doors and leave us out of the process totally. But at any rate, it appeared that not much had been done. I had said at the bottom of my complaint, I have numerous documents in my office. Please contact me for more information. No one contacted me. But here's what I determined later happened. My complaint letter was faxed by the Judicial Standards Board office to the judge herself, who turned around to use it to make a lawyer's board complaint against me. She made 20, depending on how you count, 27 or 28 complaints against me in this same missive, clearly an attempt to take my license. Now, there's a nifty thing that state appellate law has done to lawyers in this state with regard to the First Amendment. They've decided that even if the lawyer has proof that their claim of judicial misconduct was true, such as a deposition of an eyewitness or ear witness, that the Supreme Court can make a, quote, objective determination that it's not true, and the lawyer's license can be taken. Lawyers need help from the legislature to be able to speak the truth. I will not sit here and say lawyers should lie. I abhor that. They should not be reckless, but they should be able to speak to the tribunal about the tribunal. I am one of the only lawyers I know of who is willing to take on these issues, and because of that, I have attracted a clientele specifically coming to me, telling me they're having a problem with a judge. There's only one of me. I can't handle all these cases. I don't have time to stick around for the solutions part. I have a lot of ideas. Certainly, I know that there are folks here today who have a lot of ideas for solutions, but it seems that perhaps before the solutions are considered, that there should be a fact-finding committee that can actually pore over some of these documents and look at some of these documented problems, and in particular, start to discover whether or not, in fact, there are members of the bench who are afraid to speak out for fear of retaliation from other members of the bench. Those are the people who really know what's going on and have the inside track.